Hello, everyone. I'm Micah Kane, CEO of the Hawaii Community Foundation. Thank you for being with us this afternoon. I want to welcome you to our first Legacy 101 webinar, and really want to thank Judy Lee and John Roth for leading this webinar for us. Before I begin, I just want to take a couple minutes. One, first to thank some of our leadership who is on the call from our board. Like to recognize them. I'm very fortunate. We're very fortunate to be led by a great governance committee. Jeff Arce, Roberta Chu from the Big Island, Tamar Goodfellow operating out of Maui, Leah Sheehan. I want to thank all four of you for your leadership and your support of the Hawaii Community Foundation. You know, your presence as a key stakeholder in the nonprofit community can't go understated. You know, as people who are interfacing with benefactors and future benefactors in Hawaii, I just want to acknowledge how important of a role you're playing. And I think it was seen most recently in 2021, 2020, when we were facing the pandemic. You know, we saw tremendous vulnerability in our community, but we also saw tremendous vulnerability and fragility in the nonprofit sector. And I want to make sure that we connect today's estate planning webinar with the opportunity to create a lot more resilience in both of those sectors. The sector that is serving the nonprofit community, which is you, and helping to build some resilience there, but also you know, that connectivity to our community. I really think that goes understated, and the role that you play in making that connection. So really want to thank you for your engagement here. The more connected we can be and the more we can share experiences and share knowledge, you know, the better off this sector will be, and therefore the better Hawaii will be. So to our leadership team, thank you for organizing this, and to Judy and John for your volunteer time in making that investment here. Just want to extend that mahalo to you all. Thank you. I'll bring it on to Janelle. Janelle?
Mahalo, Micah. Aloha, everyone. My name is Janelle Lyman. I'm the Director of Plan Giving and Advisor Relations at Hawaii Community Foundation here. As Micah had mentioned, really today's program is the first in a new legacy series that we will be hoping to stand up soon. And we really designed today's program for those of you who are new to estate planning, but also as a refresher for those of you who have an estate plan in place and are looking to update your documents. So a few housekeeping notes before we start. We will answer as many questions as we can throughout the presentation. So please, use the chat box at the bottom of your screen and ask away. Today's presentation is being recorded. We will send you a copy of the recording and slides. So look in your email box in a few days. We will also include a survey. As this is our first virtual webinar about estate planning, we really want your feedback. So please take a few minutes to fill out the survey so we can better serve you in the future. So today we have two amazing experts who will share some tips and tools to guide you through the estate planning process. We have Judy Lee. Judy is a law partner at Goodsill, Anderson, Quinn & Stifel. She has over 32 years of experience in estate planning, probate, guardianship, trust administration, and estate controversy. Looking at Judy, this means that Judy has been practicing law since she was like 12 years old. Next, we have John Roth. John has been in practice for over 10 years. However, John was literally born to be an estate planning attorney because his father was a trust and estate law professor. And it's just in his genes. John is the founder of Hawaii Trust and Estate Council, a statewide estate planning law firm with Big Island offices in Waimea, Hilo, and Kona. both John and Judy have taught estate planning at the William S. Richardson School of Law, my alma mater. So woo woo. We are honored to have them here today to teach us about estate planning basics. Please note that John and Judy are really sharing their expertise today for educational purposes, and they are not providing legal advice or services. So with that, let's just start at square one. John, what is estate planning and what does it look like?
Okay, aloha everyone virtually out there. Thank you, Janelle, and everyone at Hawaii Community Foundation for having me. I'm honored to be part of this educational presentation. So when I answer the question, what is estate planning? It makes me think of the comic strip of a psychiatrist talking to the patient. The patient is lying on the couch. The psychiatrist is asking a line of questions. The patient's being very thoughtful and honest, answering all of the questions. And the psychiatrist gets to the question, how often do you think about death? And the patient kind of sits up and asks, does estate planning count? So I assume, oh, you are laughing out there. I can't see or hear you, but it's nice to see a lot of familiar faces in the audience, but on the names, I can't see you. Seriously, what is estate planning? It is the proactive process of putting together a plan which allows someone to carry out your wishes in the event of your incapacity or death. So being proactive is a very important part of estate planning. If you're contacting an attorney or trying to put together an estate plan when there's a medical emergency going on or capacity is an issue, it's a lot more emotional and hard to make good, well thought out decisions. And then it's in the event of incapacity or death. Yes, like the psychiatrist, we are talking about death right now, and it's not easy to do. And most times that's what people think of when they think of estate planning. But it's just as important, if not more important, is incapacity. Some people say death is easy, the plan's there, but in the event of incapacity, there's so many issues that come up that can be addressed in an estate plan as well. And ultimately, you're carrying out your wishes, which is why you have to be proactive while you still have your capacity to make your decisions, because these are decisions that you're making for yourself that you would want someone to carry out for you. So on the next slide, we're going to talk about what does an estate plan look like in terms of the basic documents. Judy will talk more about what an estate plan looks like generally, but right now, what do the documents look like? So on this slide, you can see every estate plan always includes a will. A will is the document that is most commonly thought of when thinking about estate planning. That's the document where you can say who you want your executor to be or your personal representative, who you want your beneficiaries to be or where you want your stuff to go after your lifetime. And then if you have minor children, who your guardian should be. So that's a will. And then a power of attorney is a real basic document as well, part of the power of attorney, will, healthcare directive. Those three documents are part of every estate plan. So the power of attorney is the document that allows you to appoint someone to act on your behalf during your lifetime in the event that you can't act on your own because you're just immobile, you can't get around, you're out of the country, or you're incapacitated, and something has to happen for you. This agent can step in and be your power of attorney. Sometimes people will bring in a power of attorney document to me and they'll say, oh, my dad just died and I'm the power of attorney, so I need to do this and this. And I'm like, okay, well, I can take that power of attorney and just put it through the shredder because it's no longer valid because your dad is not living. A power of attorney is only valid during the person's lifetime. And then also sometimes people will say, I need to be my parents, my dad, my mom's power of attorney. How do I do that? And I'm like, well, your mom or your dad does that. And so they need to call our office and they say, oh, well, they can't talk right now. They're not doing well. I need to help them. And unfortunately, at that point, if the person who needs a power of attorney can't make that decision, can't sign that document and appoint the agent, then it's too late. And so that person that family would have to go through a legal guardianship or a conservatorship through the court system. That would be a lot more complex and costly and time consuming than doing a power of attorney document. And so the power of attorney is everything, can be everything other than healthcare. And then there's the Advanced Healthcare Directive that's similar to a power of attorney that appoints the person who can carry out your healthcare wishes. And then you can make some decisions in advance, like whether you want to be on life support or an organ donor. And then your agent carries out your wishes. If you're in the hospital and you can't communicate on your own, they become your healthcare representative. And then in addition to that document, sometimes we'll do a HIPAA privacy release form if you are okay with your agents who would carry out your wishes in the event of your incapacity to be able to talk to your doctor during your lifetime, right now, if they have questions. So this is where, maybe mom or dad comes home from the doctors and they're having a bad day. They have good days, they have bad days, they're having a bad day and they can't remember what medication to take and they're not communicating very well. So you call their physician and you say, okay, my mom's having a hard time. What do I have to do with her medication? And the physician says, oh, I can't talk to you. Can you put your mom on the phone? I can tell her. And it's like, well, if she could communicate right now, I wouldn't be calling you. So a HIPAA privacy release form is really important if you're already kind of headed in that caretaker type relationship where you're still living and you have capacity, but maybe some bad days. And then we do a disposition of remains document sometimes if you want to make it really clear whether you want to be cremated or buried, and you can add specific wishes, what to do with your remains if you have those. All of these documents, if everyone always got along, you wouldn't have to do these documents. So these are just make it a lot easier, decrease the potential of fighting among your loved ones. Because they're just carrying out your wishes, and your wishes are very clear and laid out. And then the last document that I have not discussed yet, I'm saving it to the end, is the trust. And when I say trust, right now for this conversation, I'm talking about a revocable living trust. It's not part of every estate plan, but it is a common part of many estate plans. And sometimes you need a trust depending on what is going on, what situation you're in, what you own, what your family looks like, and ultimately what your goals are. Because there are certain things a trust can do that a will cannot do. And so during your lifetime, when you set up a revocable living trust, the document lives with you. It's without living. And it's basically a disregarded entity during your lifetime when you set up a revocable living trust. Also, if you're married, sometimes spouses will set up a joint revocable living trust. And depending on how it's drafted, the document is totally amendable. As long as you're alive, you're totally in control, you're the beneficiary, you're the trustee. Assets that are not in your revocable living trust versus assets that are in your revocable living trust, as long as you're living with capacity, are one and the same. You don't lose control or the ability to benefit from those assets. What changes when you put something into a revocable living trust during your lifetime, like transferring real estate or a brokerage account, what changes is how that underlying asset is managed in the event of your incapacity or death. Generally, it makes it easier to, during that transitional period, for someone to step into your shoes and help take care of you during your life, or take care of your wishes after your lifetime. So this is where, talking to Janelle, preparing for this presentation, the most common question, which some of you have written ahead of time, is what is the difference between a will and a trust? And ultimately people ask me, do I need a trust? And so I'm going to explain in this short amount of time we have together the difference between a will and a trust very concisely, because this question alone can be a very long conversation and is different for every person. But generally, there are three basic differences between a will and a trust. So a trust, a revocable living trust, lives with you and it lives beyond your lifetime. So the first difference is in a trust, you can control from the grave. It allows you to control how whatever you leave behind is managed for your beneficiaries. In a will, you say, I want this person to get this, I want this person to get this, however you want to split it up, but those are outright distributions, and the person who inherits them, the beneficiary, can do whatever they want with those assets, like a lump sum. So a trust allows you to control in the situation where you think it would not be beneficial to the beneficiary. We call them a beneficiary because inheritance is supposed to benefit them. But if in some situations, maybe the beneficiary is too young, maybe in terms of age, or maybe too young in terms of young at heart, and they can't manage their finances, maybe it's a special needs situation. Well, if there's a situation where you think a lump sum distribution of the inheritance would not be beneficial, then a trust is required to have any sort of provisions written in that you think would facilitate a better transition for your beneficiaries, because ultimately that's what you want to do. You want to help them. You want to make their life better, not worse. So then the second main difference between a will and a trust is that trusts will provide the opportunity to avoid probate. So real basically, probate is the process where when someone dies owning certain assets, the state says, ooh, we want to be involved because we want to make sure this is done correctly. So if someone dies owning real estate, that doesn't pass to anyone through rights of survivorship. Rights of survivorship bypasses probate. That's where when multiple people own one asset and when one person dies, the other automatically becomes the owner. Sometimes there's rights of survivorship with real estate. That does not trigger probate. But if there's no rights of survivorship, then when that person dies owning real estate, probate's triggered, or financial assets that total $100,000 or more that do not have rights of survivorship, so they're not joint with anyone, or do not have designated beneficiaries. Designated beneficiaries and rights of survivorship bypass that probate process. But if someone dies owning real estate or liquid assets that total $100,000 or more, that don't have designated beneficiaries or rights of survivorship, then probate's triggered. And so if someone calls my office and says, my mom died, she owned her home, my dad died a long time ago, she had a will. I say, okay, in the name, the property's in her individual name. I say, okay, bring in the original will that says that you, who the person who contacted me right now is the executor or personal representative, bring in the original death certificate, and we will put together an application that we put all your information in and send off to the registrar's office at the courthouse. There's different ways of doing the probate process, informal or formal. But basically you're asking permission from the state of Hawaii to give that person, the executor who's been nominated in the will, the authority to actually be the personal representative and get to the frozen assets, sell the real estate or transfer the property. But they can't do anything with those assets until they get that application processed or petition processed through the registrar's office of the courts. And that process, you're referred to as the probate process, the simplified version, is can take a few months or a year, depending on how the office or the court is functioning at any given time. And so some people want to avoid that process. So and a revocable living trust is one way of doing that. So if your home, for example, would be the only asset that would trigger probate, you would set up a revocable living trust as part of your estate plan, transfer your home into the trust during your lifetime. So then if your child, the successor trustee in the trust, calls my office and says, mom died, she had a trust, the home is in her trust, then I say, okay, come into my office, I'll draft a paragraph that says you accept your role as the new trustee because mom's no longer alive, so she can't be the trustee. And as soon as you accept your role as a trustee, you are the trustee. you don't have to ask permission from the state. And so probate is triggered in each state where you own real estate. And so the more states you own real estate, the more advantageous avoiding probate can be. And so that's the second difference. So it's controlling from the grave, a trust allows you to do, and a trust allows you to avoid probate. And then the third and final difference that I like to explain when talking about the difference between a will and a trust, I refer to as incapacity planning. So, during your life, while you're living, but you can't manage your own affairs. A revocable living trust provides for a more structured approach than a power of attorney, for example. Because I already explained how a power of attorney is a document that allows you to appoint someone during your lifetime to act on your behalf. But the power of attorney, unfortunately, is not always accepted as a valid document. So sometimes the child has the power of attorney, who is the agent, goes to the bank to get the funds to pay for mom or dad's health care. And the financial institution says, oh, no, we don't accept that document for whatever reason. Maybe it was executed too long time ago, or the name is wrong or something, not the same, or this is their policy. And so unfortunately, it's not a great document to rely heavily upon, a power of attorney. But a trust, if that same account is in trust, which means the bank account says your name, comma, trustee, then during your lifetime, you don't know that it's really even in your trust. You just know it's in your trust because it says your name, comma, trustee on the statement. But in the event of your incapacity, or if you resign, because during your lifetime, your revocable living trust is a disregarded entity, and you're always the beneficiary of whatever is in your revocable living trust if you set it up, but you don't have to be the trustee. So you can resign if you're being proactive, which I always think is a good idea. Being proactive is great. But if you're not able to resign, then you can be deemed incapacitated, and your trust can say how that's defined, how you're deemed incapacitated by doctors. Then your child or whoever you've named as your successor trustee can step in and become the trustee of your trust during your lifetime and have access to that account if the account's in your trust to use for your benefit. So that's the incapacity planning. So that's the third and final difference of the trust between a will and a trust. Janelle, do you have a question for me?
Yeah, I do have a question, John. Actually, this is actually a question that always comes up when you talk about estate planning to a donor and you're looking at all of these documents. So how much does it cost for an attorney to put together these basic estate planning documents?
So I get that question a lot too. It's really hard to answer. There's a very wide range based on what your family looks like, what your assets look like, what your goals are, so what your documents have to say. So the range is not going to be very helpful, but it can range anywhere from $2,000 on the more simple side to $10,000 on the more complex side. So it's just a good idea to get a quote before you engage, so you know what you're getting into, because it does provide peace of mind, but it is an investment.
Okay, and then another question, does everyone need an estate plan?
So I'm going to answer that question real quick with the next slide, because everyone always says, what is the best estate plan? And the best estate plan is what's chosen by an informed person based on a current life snapshot that ultimately provides peace of mind. So if you already have peace of mind, then technically you might not need an estate plan, but everyone gets to peace of mind in a different way. And as an estate planning attorney, I always say, if you're worrying about it, then you should probably have one. And so even if you don't need an estate plan because you're just a person with peace of mind all the time, no matter what, Judy will talk next about how everyone has an estate plan, whether you've seen an attorney or not.
Thank you, John. It really, as John indicated, it's a pleasure and a privilege to speak to you today on behalf of the Hawaii Community Foundation. So now that John has spoken to you about creating the best estate plan, I'm going to reinforce the great information that John provided from the opposite direction and discuss estate planning mistakes to avoid. So from my perspective, the following are the top 3 estate planning mistakes to avoid. And they are, first, 1, not purposefully establishing an appropriate and integrated estate plan. 2, establishing an estate plan without the assistance of competent counsel and other advisors. And 3, failing to regularly review your estate plan, both independently and with your advisors. So let's talk about these mistakes. So the first mistake is to avoid is not purposefully establishing an appropriate and integrated estate plan. And the key words here are purposeful, appropriate, and integrated. Now, it's important to be purposeful in establishing your estate plan because everyone has an estate plan, whether or not they've ever seen an attorney. And part of it is a result of the laws of intestate succession. So if you don't have a will and you pass away owning assets in your sole name, essentially the state writes the will for you. And they write the will based upon the laws of intestacy. Now, the state tries to write it up in such a way where they believe most people would have wanted the assets to be distributed. So in many cases, it might be perfectly fine. However, in many other instances, it really might not meet with what you intended. So for example, if you're unmarried, your parents have passed away, and you have 2 siblings. One of the siblings is your best friend. The other one, you guys had a falling out. You haven't spoken to him in over 20 years. Now, if you pass away without a will, your individually owned assets will pass equally to your 2 siblings, even though you only wanted it to pass to one. And in some instances, I've heard, I could tell you lots of stories of unfortunate situations where people intended and would have wanted their estate to pass a certain way, but unfortunately, because they never got around to establishing a will, it passed under the laws of intestacy. Now, John explained that the will only addresses the assets that are in your sole name without a beneficiary designation. So what does that mean? Sole name. Well, a lot of people actually own assets jointly. So for example, most married couples own their assets as tenants by the entirety. And under that form of ownership, when one person passes away, the survivor will become the sole owner. You can also have beneficiary designation assets. And in fact, a lot of you probably have significant value in beneficiary designation assets like life insurance and retirement accounts. And yet, in many instances, people don't give the selection of the beneficiary much consideration. So for example, if you are meeting with your employer for the, you had just gotten hired and they give you a form to fill out to say, okay, if you pass away, we have a policy where we'll pay out $100,000 to your beneficiary. Some individuals will just fill it out without giving it much thought. So establishing an appropriate estate plan is important. You have to think about how the plan will impact your beneficiaries depending upon when you pass away. So this is where I think a lot of people, and I definitely hope this is the case for all of you, will live a good, long, healthy life. And from that perspective, you might set up your plan thinking that, oh, this is all going to take effect many years from now after I pass away, after, you know, at age 95 or maybe longer. However, it's possible that circumstances might not work that way. And for example, if the individual became incapacitated and the individual only did a will without doing a trust or the power of attorney, as John had John had explained, they may pass away. They may become incapacitated and not have anyone able to manage their assets. So it's really important in thinking about the estate plan. It needs to be an estate plan that takes into consideration some other contingencies. Now, the estate plan needs to be integrated. A moment ago, I said a big part of many people's estates are their retirement plans and their life insurance policies, but they might have signed those beneficiary designation forms many years ago and not really thought about it as they got older. And I had a circumstance where actually a person had designated his mother as a beneficiary under his life insurance policy, and subsequently decided that he wanted his entire estate to pass to his wife, but he never changed the beneficiary designation. And of course, the wife, looking at the will, thought, oh, I'm going to get everything, not realizing that the beneficiary designation actually superseded, because the will only deals with the assets that are owned in the person's individual name without a beneficiary designation. So the key objective to the integrated estate plan is that it should provide for you during any period of incapacity. John stressed this point, and also coordinate the disposition of your entire estate in an appropriate manner at your death. So that brings us to the second mistake to avoid, and that is establishing an estate plan without the assistance of competent counsel and other advisors. Now, I am sure many of you are very intelligent people, and you've read a lot of articles. You attend programs like this one on estate planning, and you have a good general understanding of these concepts. But I do want to stress that estate planning is not a do-it-yourself project. I am the first to admit, if I have a leaky pipe or a broken item, I would be on YouTube trying to watch videos to figure out a way to fix it myself without having to call a plumber or to buy a new item. But trying to establish your own estate plan without the assistance of professionals can actually result in more damage than good. And that's because the field of estate planning is a complex area of the law. It requires knowledge of income, gift, estate, generation skipping, transfer taxes, as well as an understanding of other fields of law, such as real property, corporate law, and litigation. A competent estate planning attorney will have a working knowledge of these issues. They will have a working understanding of life insurance, pension, partnerships, corporations, LLCs, and much more. So estate planning has become a very specialized practice area for attorneys. And generally, those who devote a substantial portion of their practice time to this work will take the time to keep up with it. And that's something that we'll mention as we go on, because I do recognize there was a question about changes in the tax law. Now, for that reason, I would not recommend using a software program to prepare your own estate planning documents.
Judy, when you talk about software program, do you mean things like, LegalZoom, We the People? I think there's another one, freewill.com. Is that what you're talking about?
Yes, and the reason I would not recommend using those types of programs is because essentially you miss the very valuable piece of having an attorney who specializes in estate planning, who can match the right tools, provisions, options to your unique situation. Because good estate planners will not use a one-size-fits-all form. They will spend the time to get an understanding of your situation in order to develop the plan. And in fact, I'm going to mention something that I think pretty much happens in all of my meetings. And that is the question of what if? Because some of my clients will come in and some of them will even write things up, and they write it all up and they say, this is how I want my plan to be. But as I mentioned a moment ago, in many situations, the clients aren't thinking about the unusual, the possibility of unusual things are happening. Just as the clients are optimistic about their own health, many times they're optimistic about the health of the people who they designate as their beneficiaries. So the clients might say, okay, I want everything to go to my kids. And then I say, oh, well, what if your children predeceased you? And many of the clients honestly will just say, what? I never thought of that. Mm-hmm. And as I mentioned, if they don't have a will, the state writes one for them. So this laws of intestate succession will apply even if you have a will or a trust, but if you did not designate beneficiaries who are surviving. So if there was a catastrophic accident and the entire family passed away, essentially now the assets will pass to the person's closest living relatives. And I've had clients tell me, hey, I would roll in my grave if my cousin Freddie got my house that I worked so hard to acquire. Instead, many of these individuals would say, hey, I would want it to go to a charity that I've supported and whose mission I really have a passion for. And those are important things to consider in the estate planning situation, the what ifs. The other piece is not just beneficiaries passing, but the individual's assets changing. Because in some instances, people will find that they thought they were going to have certain things, and perhaps they anticipate they set up their estate in that way, designating a whole bunch of specific gifts to people and the remainder going to their primary beneficiary. And unfortunately, I've had situations where the estate was diminished and the people who were getting more money was the ones with the specific gifts. So, best case scenario, everything works the way that you plan. But I think as this past year has shown all of us, life is not always predictable. So it's important that the estate plan take into consideration other possibilities. The other part that a competent estate planning attorney can help the individual with is selecting the nominating the proper person to serve as successor trustee, agent under power of attorney, or personal representatives. And many times people will just say, oh, I'm going to name this person because they're very trustworthy. It's important that they understand what are the actions that the successor must do and really take into consideration perhaps where that individual will be in his or her life at the time that you become in need of having someone manage your estate. So there could be other advisors in addition to the attorney that should be involved. And many times, especially when you're involved in doing irrevocable trusts, it's important to include financial advisors and accountants. And then that way there can be a coordinated plan. Now, I'm looking at time, so I'm going to talk about this pretty quickly, but the third and last mistake is failing to regularly review your estate plan independently and with your advisors. So, as I said a moment ago, things change. Relationships change. Now, change in relationships can have a substantial impact on who you want to designate as your beneficiary and fiduciary. Some people do their estate plan and they just put it aside. They don't think about it anymore. And then when just so happens we go over it and I mention who they designated, they're shocked because it might not be people that they'd like to include anymore. The other thing that changes are assets. And just as I've had situations where the assets of the client has diminished, I also have some very happy situations where their asset values have multiplied many times over. And in such situations, the plan that we might have established before for the client might no longer be sufficient because that client might have estate tax concerns. Or the nature of the assets might have changed. Some clients might have started a business and now they need business succession planning incorporated into their estate plan. And then the one that many of you have been inquiring about, the law could change. And I think many of you are aware of the potential significant tax law changes that are being considered. So I think at this point there, Janelle, was there a question about taxes that was presented?
Yes, there was actually. So the one question that came in was, what changes in the inheritance tax do you anticipate being made under the Biden administration?
Yeah, so this is definitely a question that many people are discussing and speculating about. I don't know if you're familiar with the term, but there is a green book, that's what it's called. And it basically contains revenue proposals dealing with tax issues. And it was recently put out by the Biden administration. And it sets forth some very far-reaching changes. Now, I'm not going to talk about income tax and some of the other changes, but probably the most significant potential change for estate administration is the implementation of a capital gain tax at death. And if this change is implemented, the beneficiaries of a decedent's estate might be subject to capital gain tax. Now, capital gain is determined by subtracting the decedent's income tax basis from the fair market value of the assets at the time of the decedent's death. So if the decedent had invested well and purchased real estate and stock at a low price, and the real property and the stock had greatly appreciated, the heirs might be subject to capital gain tax. Now, there are some exemptions in place. So the proposal does contain that, you know, if this amount of the capital gain does not exceed $1 million per person or a couple million for a couple, it might, you know, the capital gain tax might not be imposed. But I will tell you, living here in Hawaii, it's entirely possible that people could have purchased real property, you know, for 100,000. And the home could easily be worth now, you know, 1.3 million. And you put that together with a good stock portfolio that might have been started off with 100,000 and is now worth, you know, another million. You can easily go over those exemptions. So,
but all this definitely is like, it's speculative, right? Because it's just proposals. So really just better to plan than have to predict something, right?
That is definitely the case. I always tell my clients the most critical laws are the law that is in effect when you pass away. Of course, we cannot predict when the person will pass away and the laws that will then be effective. So most definitely, it is better to plan than to try to predict.
So Judy, we have 10 more minutes and we'd like to leave this open for questions now. There are some questions that have been coming in. And the one question, I guess, maybe for John to answer are there any particular locations that the estate planning documents should be stored in?
Okay, well, Great presentation,
keep it
good
short.
information. Thank you, Judy. Yeah. A safe place in your home. A lot of the biggest mistake is to put it in a safe deposit box that's just in your name. If you're going to put it into a safe deposit box, and you have a trust, make sure the safe deposit box is named within the trust. Or if you don't have a trust, if there aren't any valuables that are worth a lot, it's just your documents. Sometimes people will put like one of their kids' names on the box with them because it's really hard to get to that box if their name is the only name and it's not in their trust.
So what about in your refrigerator?
I've
had a client
That's
do
fireproof.
that.
Yeah. I mean,
Okay.
a safe place. Just make sure that whoever you've appointed as the person who steps in to help in the event of your incapacity or death knows where they are.
Okay. And so Judy, another question, you talked about kind of an estate plan, which is integrated, coordinating disposition of the estate through your will and trust, beneficiary designations. What assets should be titled in your trust?
Okay.
That's the question.
As a conservative estate planning attorney, I always tell people put them all in. And that's because a lot of times people will say, oh, especially married couples, they'll say, well, after one of us dies, we'll put it into the trust. But you just never know. One person could pass away, the other survivor could be incapacitated at that time. But at the same time, I'm also practical. And I tell people that, I don't want you to do things that are going to make things overly complicated for you. So in many instances, what individuals will do is they will continue to maintain a checking account that is not in the trust, and they'll have it joint with people who, perhaps they feel, and most of the time it's a married couple, it would be the other spouse. Sometimes it could be a child, but somebody who will help them in, managing things, and they can access those assets quickly. But the key here is not the major assets. It's not, some people have hundreds of thousands of dollars in their checking account. What I'm talking about is a small in and out account. And that's also because, as John had indicated when he spoke about probate, in the state of Hawaii, if you have assets in excess of 100,000, then, and that's total, not just one account, in total, in your individual name, and it does not involve real estate, you don't need probate. So if you have a simple checking account that is in and out type of thing, and lo and behold, both people passed, well, it still should be possible to collect that account through an affidavit of collection.
So there is a question that actually came in, and it says, so this individual is a healthy, but perhaps aging, definitely aging, and she's co-trustees on her trust, and bank accounts and house with the son. The question, she says, do I need to change anything if I'm co-trustee with my son? How does the co-trustee situation work?
Well, I would say a lot depends on, oh, sorry, John, you want to answer that?
No, I just had something pop up on my computer.
Oh, not a problem. But, well, the co-trustee situation, you really have to take a look at the trust document.
Mhm.
You have to see, some trust documents require that co-trustees act together. So if that is the case, and if it's a situation where that makes it difficult for the management, you may need to look at it and see what might be a better way. Sometimes you can delegate authority amongst co-trustees, and some of the institutions will accept that type of thing. It really boils down to, I'm sorry to say, what does the trust instrument provide and what kind of powers are given? I've even seen trust instruments where certain co-trustees are given certain powers and others are given other powers.
Right,
Okay.
and depending on what the goals of the client are, right? So when a parent puts a child as a co-trustee of their revocable living trust, since it's a revocable living trust, the parent really isn't giving up control, because they can always, revoke it or do something with their own revocable living trust. But the security of having a child as a co-trustee provides some safety from potential predators that could take advantage of an elderly person.
Okay, another question that came in, can you use a transfer on death deed to transfer your property into your trust upon death rather than transferring it ahead of time? John or Judy?
What do you want it? I mean, transfer on death deeds are definitely allowed in the state of Hawaii. And so they are similar to designated beneficiary provisions for retirement accounts or life insurance, where it bypasses probate and goes to whoever you've designated on the transfer on death deed. I don't know your experience, Judy, with the transfer on death deed though, but in my experience, because they're more recent, I find that institutions don't really understand them, and sometimes they're not kind of, it makes it difficult to borrow against the property or qualify for certain things. I've run into that situation where people viewed it and they didn't loan to the property because of the transfer on death deed, and I had to explain to them, and people don't really understand what it means when it shows up on a title report.
Wow, that's unfortunate, because clearly the law provides that the transfer on debt deed, we call it the TOD, is revocable. So it really should not have an impact on the owner's ability to, take out a loan and mortgage the property. Some individuals have designated their trust as the TOD beneficiary. So I think that was the specific question that was being asked about. Rather than putting it into the trust right away, why don't I just designate the trust as the beneficiary under the TOD? The thing about it is that, of course, then there are some steps that needs to be done by the beneficiary in order to have the title, indicated to be in the name of the beneficiary. So,
and then just like any designated beneficiary, yes, it bypasses probate. It's a great tool. I love designated beneficiaries that can go straight to that person. But if in the event of incapacity, you're not deceased, then you're kind of stuck because the property's in your individual name still.
exactly.
That's true.
Harder to manage. So incapacity is a big part of
So
Then
there
why
is
you want to put
another.
things into your trust during your lifetime.
So there is another question about, should real property be titled in the name of the trust? What are the advantages and disadvantages of doing so?
Okay, so the advantages I know John went over is avoid the probate. That's the big one. And plan for incapacity. In the event that you become incapacitated, the designated successor trustee would be able to take action regarding the property. One of the disadvantages is the very thing John said. Sometimes lenders, and clearly under revocable trust, not the Todd situation, I have had situations where lenders had said, before we will issue a, before we can do the mortgage, you got to take the title out of the trust, put it in your individual name. If it's your primary residence, there's a law that says they're not supposed to be able to, prevent you from putting it back into the trust. But in some instances, that's extra, what should I say, expense of the deed to take it out, to put it back in. So that could be viewed as a disadvantage.
So we have just about 4 more minutes. I do want to take maybe 2 more questions. And this may be more for a Legacy 201 type of series, but one of the first questions is advantages and disadvantages of a health education trust or a charitable remainder trust. So on the charitable remainder trust, advantages and disadvantages, Hawaii Community Foundation, we do have a few brochures that we can be able to send out to you, or our contact, either anybody in the Community Foundation, myself, we have officers on each island as well. We can certainly have that conversation, but this is new to me, a health education exclusion trust.
You can answer, Judy. We talked about this a little bit earlier.
Here's the thing. Their estate planning attorneys are actually noted for being, in many instances, great marketers. And in many instances, there will be specialized type names given to different types of trusts. But in general, the trust would, my guess is this, I don't know the specific in terms of how this term was used by a particular company or the like, because it is not something that is just bantered around. It's not like a common irrevocable life insurance trust, qualified personal residence trust, things like that. For the most part, my belief is that it would be an irrevocable trust that would take advantage of both the education exclusion, so the payments that you can make for qualified education expenses, as well as the payments that can be made for qualified medical expenses. So again, once you get into these more unique type of estate planning vehicles, it's a good idea to talk to somebody who understands estate planning and who is willing to take the time to really understand your personal situation.
And the final question is, what is a legacy endowment? And so I'll actually kind of answer that question because it is charitably related. So it is an endowment that's a permanent gift to a charitable organization or a fund where the capital and the principal is invested, and income or a set amount is available to grant out for grant making. These endowments create a legacy, a lasting legacy for the donor, because it provides for ongoing, regular, sustainable support to the charity or a specific community interest. So we do have only one more minute left. Judy and John, you have any last words, comments? Nope. Okay. Thank you very much. I want to mahalo you for sharing your expertise. An email will be sent out to everybody for the recording and slides. And we would just want to mahalo you for your time.